Hi guys, welcome back to my channel. I am Ksenia and I make videos for people who are going through the family immigration process. I'm not an immigration attorney. My videos are based on publicly available information, my own experience, and the experience of my subscribers, and the purpose of my channel is to give you guys the confidence to go through this process completely on your own. In today's video, I will be answering some of the more common questions that I received in regards to parent petitions or parent green card cases. And before I proceed, please be on the lookout for a playlist that I have made dedicated to parent green cards, parent petitions. And so now without further ado, I'll start answering some common questions. Question number one that I get quite frequently is, can I petition my parents if I am not yet a US citizen? Only US citizens are eligible to file petitions for their parents. Another question in regards to this is, can I file a petition for my parents if I'm not yet a citizen, but I already have my naturalization ceremony scheduled? And the answer is also no, because at the time of filing the I-130 petition, you will be asked to provide proof of your citizenship, specifically a copy of your naturalization certificate. So in this situation, you cannot file the petition too early. The next similar question is, can I petition my parents if I'm not yet 21? According to the Form I-130 instructions, the petitioner must be a US citizen over the age of 21 in order to be able to petition his or her parents. I have seen one case where a petitioner filed the I-130 petition only a couple of months before they turned 21, but ultimately this petition and the entire adjustment of status application that his parents submitted afterwards was denied because the petitioner was not 21 at the time of filing the I-130 form. You may file the I-130 petition on your 21st birthday, but not a day sooner. The next question is, can I petition for a step-parent? Generally, yes, but it all depends on a couple of factors. The first criteria that you will need to meet is that the marriage between your biological parent and your step-parent must have occurred prior to your 18th birthday. And the second thing you need to consider is that at the time the marriage between your biological parent and your step-parent occurred, they were legally free to marry. This means that any prior marriages that they may have had were legally finalized, because you will be asked to provide proof of that in a form of a divorce decree. Next question that I get quite frequently, and that is, can my minor siblings be included on my parents' petition or green card case? And unfortunately, no. As a US citizen, you must file separate petitions for each eligible relative. Only certain types of relatives allow for a derivative to accompany them, but unfortunately when it comes to parents of US citizens or immediate relatives of US citizens in general, they do not allow for a derivative. So you can see that in the Form I-130 instructions right on page 1. Siblings of US citizens, no matter how young they are, may not accompany the parents of US citizens. The siblings of US citizens fall under a preference category F4 on the visa bulletin. And as you can see, the wait times for siblings of US citizens is anywhere between 15 to 25 years or even longer in some cases, depending on what country of origin they come from. Some applicants choose to go a different route, where as soon as one of the parents of US citizens obtain a green card, they then petition for this minor sibling as a child of a permanent resident, which falls under the F2A category on the visa bulletin. And although at this time children of permanent residents are not eligible for concurrent filing, the overall wait times are significantly shorter than siblings of US citizens. The next question is, can I file for my parents while they're visiting me in the United States? And it all depends on your personal circumstance. I am in no way qualified to give advice on this topic to anybody, but based on the public information, based on the form instructions, one thing you need to keep in mind is how long it may take for your parents to obtain their green card if you do choose to file for their adjustment of status while they're visiting you in the United States. And I do have a video which you can find in the parent petition playlist, which talks about 2 things that you really need to consider before you file for your parents, such as the possibility that they may be stuck in the United States for up to a year, or in some cases even longer, and they may not be able to go back home. And if they do end up leaving the United States without an approved advance parole document, this may screw up the entire case, and you will have to file additional paperwork and wait additional times in order for you to restart the entire process through consulate. So before you decide to file for adjustment of status for your parents, and even before you decide to file a petition for them, you need to keep those 2 things in mind. And again, I discussed them in more detail in one of the videos on that playlist. Okay, the next question is, do I have to file 2 separate I-130s for each parent, or is one enough for both of them? You must file a separate I-130 application for each parent, and you must pay a separate fee. The next question is there an interview for parent green card cases? For those of you who are filing for adjustment of status from inside the United States, there is no green card interview for parents of US citizens. The only appointment that they would really have to go to is the biometrics appointment. When it comes to consular processing, every single applicant gets an interview, and they must show up to that interview in order for their biometrics to be taken, to present certain documents, and also given their passport in order to receive the immigrant visa sticker in their passport. And by the way, the petitioner does not have to go to the consulate interview. The next question is processing times. This question is very frequent, and unfortunately, there is no real way to tell how long your case is going to take. And the processing time estimates on your USCIS account, or if you use any kind of tracking applications, are not accurate at all. Each case is different depending on the specific circumstances of your case, as well as where it is being processed, what service center, which field office, which consulate. Unfortunately, there's no real way to tell, and the only thing you can do is stay patient and wait. Okay, the next question is kind of specific, but I think it's worth addressing it here. My parents were never officially married, and father's petition is asking for the marriage certificate. What can I do? So you will need to provide way more extensive evidence, which you can also find in the Form I-130 instructions, which talks about what kind of evidence you may submit if you are filing for your parent as a petitioner born out of wedlock. You will need to prove that your father legitimized you before your 18th birthday by providing proof of your relationship over the years, proof of financial support. Some applicants even choose to take a DNA test, but all of that, again, you can find in the form instructions. And in a situation like this in particular, I highly recommend that you consult with an experienced immigration attorney who has had a case like this before, who can point you in the right direction. Next question, will my parents' cases process together, and will they have the same consular interview? Not necessarily. The NVC will make all efforts to process the applications together and to set up the same consular interview for both of your parents, but it is not guaranteed. The next question is, my parents have overstayed their visa. Can I still file for them? The great news is that your parents would fall in the immediate relative category, which comes with certain perks. Immediate relatives of US citizens, when filing through a family-based petition, are forgiven for their visa overstay as well as unauthorized employment, but both of these violations must be disclosed in the Form I-485 in Part 8 inadmissibility questions. That is, of course, if your parents have not violated any other conditions, such as they did have a legal entry with a visa to the United States, and they have not violated other immigration or general laws. The final common question that I receive is, can my parents visit me on a tourist visa or a visa waiver program while their case is still processing? And the answer to this question is somewhat complex, and again, it all depends on the personal circumstances of your case. However, what you need to keep in mind is when using a non-immigrant visa, such as a visitor visa, to travel to the United States, the person traveling must prove to the Customs and Border Patrol that they do not have an intent to remain in the United States forever and eventually apply for a green card. They must prove to the Customs and Border Patrol that they're purely using their tourist visa to visit for a short period of time, and then they do have ties to their home country to then return and continue through a consular process. Every situation is different and every customs officer is different, and they may use their discretion to not necessarily allow your parents into the United States. Now, although if you check out many Facebook groups and comments, people will generally tell you that it is quite possible to travel to the United States on a visitor visa while you have a pending I-130 case or a pending consular case. But again, it all comes with certain risk, and nobody will know for sure until you are actually at the border seeking admission to the United States. But the other thing you need to keep in mind is that if your parent is currently in the United States and you have already applied for their adjustment of status, they cannot use their visitor visa to leave the United States and attempt to come back in, because at that point they would have abandoned their I-485 application, which will ultimately be denied. They will have to apply for something known as advance parole document, which will allow them to travel temporarily and come back to the United States while the adjustment of status application is processing. But unfortunately, the advance parole document takes a very long time to process, as long as 9 months in some cases. And in a lot of recent cases, most applicants don't even receive their advance parole at all, and instead receive the green card approval right away. I will also link 2 videos under this video from an immigration lawyer who discusses this particular topic as well. So I hope that you found this video useful. Subscribe to my channel if you have not already. And again, check out the playlist which I have made in regards to parent petitions, parent green card cases. So I hope to see you guys in my next videos. Bye.